Morning. Be seated, everybody. All right. This is Civil 2026-004194. It's argument on a motion to dismiss, and also it's a Rule 16 conference. Counsel, announce on the record, please.
Your Honor, Laura Sixkiller and Dallas Myring for the plaintiff.
Thank you.
Colin Campbell and Angel Lockhart for the defendants.
Okay. Who's arguing the motion? Which one of the two of you is arguing?
Laura will be.
Oh, sorry, Your Honor.
All right. So let me just tell you what I'm struggling with respect to this motion. And they're related issues. So one is if I've got more than one form selection clause that covers the same dispute, how do I decide which one controls? Is it recency? Is it specificity over generality? Is it just, which one seems to most apply? I looked hard. I didn't find any cases that help with that very specific contract interpretation issue. Plenty of things that talk about interpreting within a contract, but trying to harmonize multiple contracts. And then the related issue is, does the case law suggest I should be going on a claim by claim or damage by damage basis and saying this one goes here, this one goes there, this one goes to this other state? Or am I making a decision for the case as a whole? And I know what your positions are, but I don't know the legal authority that would support either one. So that's really what I'm struggling with. So with that, Mr. Campbell, you're on.
Thank you, Judge. Just to begin, I think what's unusual about this case to me is that the parties have the wealth to litigate this case everywhere. In fact, both sides already have attorneys in London dealing with the sale of the cricket franchise. Greenberg has offices in Delaware. We associate with offices in Delaware, so everyone can go to any forum. You have three form selection clauses that are important. One is the stockholder redemption agreement, the other the shareholder agreement, the other the deed of settlement. The difficulty, as you point out, is how do you honor the contracts between the parties? We also agree with you that the law doesn't provide a clear way in which you resolve these differences. Our position is the court should start with a presumption. We have a shareholder agreement. That is the first agreement in time. And the shareholder agreement says any dispute between the parties is going to go to Delaware. That's not irrational. I mean, Delaware has the best business court in the country, and it's not unusual for people to choose.
Second best.
Second, well, maybe I'm thinking of the Chancery Court there, Your Honor. But
I'm kidding. I'm not.
So I think the presumption is, I think the court should start with a presumption that these are clearly disputes between shareholders. They should go to Delaware and then ask itself, should I carve an exception out of that for later in time agreements? So we have an exception for the stockholder, not the stockholder, we have an exemption for the redemption agreement, and we have an exemption.
The redemption agreement is much more specific than the broad shareholder agreement, and it's also later.
Right, and then we have the deed of settlement form. So we look at this as a claim by claim basis. I mean, the form selection clause.
So let me ask you the law question. I think I know the answer. Have you seen any case that says you do or don't parse out individual claims? And how does it make sense to take what's really one dispute and multiple causes of action and send it to three different courts?
Let me start with the latter question. We think there's three baskets of claims in this case. So let's look at the first basket. To the extent they're arguing securities fraud or breach of fiduciary duties, those claims have to do with this issue of preemption, that we didn't file a lawsuit with respect to or either a derivative lawsuit or a direct lawsuit with respect to the idea that the stock was valued down over time. That has nothing to do with the stock redemption agreement at all. That is an entirely separate claim. Now, the fact that the damages that arise from it may be the same measure of damages doesn't mean they should be put together. The claims are entirely different. So we think with respect to fiduciary duty, fraud, bearing upon this preemption issue, those clearly belong in Delaware. And there's nothing that happened later that carves it out. Now, we have the stockholder redemption agreement. Well, clearly that agreement itself belongs here, and the court has heard testimony with respect to it. They've made new claims with respect to purchasing B stock that he didn't get a dividend payment and he didn't get a tax refund. We agree those should belong here under the redemption agreement. But that's the only thing that belongs here. If you look at the third basket of claims, this has to do with the deed of settlement, which after the hearing, the court said this results in a ratification. But their arguments on the deed of settlement, and these are new arguments they've come forward with in the amended complaint. On one hand, they say there was fraud in the inducement with respect to that deed of settlement. Well, that doesn't belong here. The deed of settlement belongs in England. That's what everyone agreed to. And if they think they were fraudulently induced to the deed of settlement, that should go to England.
So let me talk to you about the deed of settlement. And I've spent lots of time with it. It is not an overarching agreement. It seems to me it's a very specific agreement to deal with a very specific part of a larger transaction. And it's really meant to deal with two sides, the EMVSG side and the Royals US and Simmer Mayo side. It doesn't, for example, expressly deal with what Royals is going to do once it gets the money from SG. I'm trying to remember if it even requires, I don't think it does, because there was a separate purchase and sale agreement from that actually affected the sale of the interest, right?
Well, there's a separate sale of the product where the proceeds then go for the final purchase. So the issues with respect to the deed of settlement, I mean,
it's sort of a tripartite deal where there's no written contract for one of the legs, right? So between SG and Mayo and Royals, you've got the deed of settlement. Between Royals US, I said Royals, it's Royals US. Between Royals US and SG and EMV to sell the interests, there's the separate, which I don't think I even have a signed version of this, but separate purchase and sale agreement. And as between Royals US and Mayo, there's nothing except maybe the stock redemption agreement.
Well, no. I mean, Mayo signs the deed of settlement.
Right,
We
to get his
sign the deed of
$1.5 million
Right.
in exchange for the release.
Right, and what they do, they carve out of the release the preemption claims. You know, that was
Well, really everything. I mean, it's that you're right. There's a specific carve out for the preemption, but it's clear it's carving out any other claims, which would include, and this is really the point I'm getting at, it would include the claims that Mayo might have against his ex-partners. That's specifically excluded.
There's not a release of claims under the stockholder redemption agreement. There may be ratification.
Well, I've already found that preliminarily. So
But to the extent they're trying to void the deed of settlement as fraud in the inducement, that has to go to England. To the extent they're saying there was a collateral agreement, we have an integration clause in the deed of settlement.
Yeah, the integration clause is a pretty narrow integration clause.
Well, it would certainly.
It says concerning the released claims.
Well,
it doesn't say this is an integrated agreement regarding all agreements between all the parties in this transaction.
Well, it doesn't say there's a separate oral agreement.
It definitely doesn't say that.
I mean, which is what they're trying to argue. So,
Yeah.
I mean, that's going to be a question of contractual intent and application to the facts. But the point of this, Your Honor, though, is we think the contracts do require the court, even though the law doesn't give you clear guidance as to how to, it doesn't give you a stepwise process. We think you do have to honor all the agreements, and that some belong here, some claims belong in Delaware, and some belong in England. And the parties, there may be, as the cases proceed, assuming there's not a settlement at the end of the day, there may be some collateral estoppel consequences if one issue overlaps and it's decided in a particular forum. But the parties are well versed to deal with, consolidated discovery or how the cases are going to proceed. So what we ask is the court to honor all of the forum selection clauses, because their argument, as you know, is to let's just do everything here.
Thank you. Ms. Sixkiller.
Good morning.
Morning.
Your Honor, you asked whether you have to go overall or claim by claim. Let me start first with whose burden it is. In our first amended complaint, we expressly plead that the forum selection clause in the stock redemption agreement controls and is binding. So the fact that they brought a motion challenging that and inserting other ones, they still have to show that how these claims don't fall within the reach of the stock redemption agreements clause, which uses the word exclusive, both for the forum and the venue. Now, under either scenario you apply, Your Honor.
Do the other ones not use the word exclusive?
I don't think they have the word exclusively in Arizona. Okay. I can pull the exact language up again, Your Honor, but I don't recall it.
I've got it somewhere. So.
And the other key thing, if you look at the language, there's really two buckets when you're interpreting forum selection clauses and similar arbitration clauses. You would look at sort of the smaller, narrow bucket of just arises out of. Then you have the broader bucket, which is at issue here, which is the arising in connection with. The in connection with, the courts interpret the same as relating to that broader bucket of categories. And I can give you a site. It's not in our brief, but because there was new arguments raised in the reply, I can show it to you.
A site for which proposition?
The proposition that in connection to is interpreted the same as the
So in connection with means the same as relating to?
Yeah, so it lists arise in connection with among the broad phrases distinct from the narrow arise out of. And the site is Phillips v. Audio Active. It's 494 F3rd 378. It's the Second Circuit, 2007. Now that ties back though to a case cited by defendants, Florida Chemical Company v. Flowtech, where they interpreted relating to as, quote, I can't even say this word, I don't know if I'm going to say it correctly, paradigmatically broad and not tied to causation. So effectively, when you're in that bucket too, it's not tied to causation. It effectively turns on, does it touch on the agreement?
So let's talk about recency. Do you agree that if there are two contracts between the same parties that cover the same subject matter, the later one controls over the former one as basically a modification?
That would apply when they cover the same subject matter, which would be the stock redemption agreement, which supplanted as the shareholder agreement's redemption term.
Oh, so my agreement is about the deed of settlement and waiver, which has, let me look at the language. All disputes that may arise out of or in connection with, which as you say is broad, the creation, existence, validity, etc., by this deed. Is that not a modification, at least as to the subjects covered by the deed of settlement? Is that not a modification, or it prevails over the stock redemption agreement?
The deed of settlement makes no reference to Royal's U.S. shares. And if you noted the last words, you said by this deed, created by, arising out of this deed. The action is not arising out of this deed. Do you want to know why?
Well, it's an action claiming that you were defrauded into entering into this deed, an action that arises out of or in connection with the creation of the deed.
We're affirming the agreement. So if
You're affirming what agreement?
The July 25 agreement. Our fraudulent.
I'm not asking about the July 25 oral agreement. I'm asking about the deed of settlement.
And I'm getting there, Your Honor. We are affirming the deed of, we're not challenging the deed of settlement. It doesn't arise out of the deed of settlement. What we're saying is they defrauded us by not honoring the promises that was a condition precedent to. So we seek affirmative performance of those obligations, Your Honor.
Well,
Damages.
let me read to you some of your allegations. I first thought that that's what you were doing, except paragraph 124, in connection with the purchase of the securities, there was misstatements in connection with the purchase of the securities that led to the execution of the deed of settlement. Paragraph 144B, failure to disclose in connection with the deed of settlement. So it sounds to me like at least some of your allegations are that there were misrepresentations, affirmative, and failure to disclose, which could be fraud or could be breach of fiduciary duty. But the consequence of those things are Mr. Mayo entered into the deed of settlement. Is that an allegation?
It is, but it's a partial. Just because the deed of settlement is referenced doesn't make it controlling or over the top of the stock redemption agreement. What
You are not seeking to set aside the deed of settlement.
Not at all.
correct?
If you look exactly at paragraphs,
Are you seeking to set aside the oral July 25th agreement?
no, we're seeking to enforce it, Your Honor. So
Okay.
effectively, we're saying we were fraudulently induced to perform. We performed. Now you guys have to perform. So if you look specifically in paragraphs 132 and 133, we seek, well, that's the fraud, that's the securities fraud count. Let me see the actual fraud and inducement, Your Honor, which is the count 9. Count 9 says that it was as part of the inducing, paragraph 182, as part of inducing Mayo to enter the July 25 agreement, right? They made these promises. Then you look to 188, Mayo has suffered damages, including without limitation, the recovery of the.
So I guess if you're not seeking to set aside an agreement induced by fraud, why is that a fraud claim and not a breach of contract claim?
Because we're saying that they have an obligation, we have the breach of contract, but to the extent there's not a contract, and that's why we have a promissory estoppel. It's all in the alternative, Your Honor. We have, you fraudulently made us act. Now we acted in reliance. You have to give us our damages for acting in reliance.
So let's talk about securities fraud. It's been a while since I've had a securities fraud case, but I don't recall many securities fraud cases that say we were fraudulently induced to enter into this transaction, so please enforce the transaction. Is that a thing?
So that claim relates to not the deed of settlement. That claim relates to our agreement to sell our Royals US shares. It's separate from the July 25 agreement. So with the securities fraud agreement, is because interestingly, Arizona securities.
I'm looking at your allegation under securities fraud, and it says that the statements 124 were made in connection with the events of June and July 25 that led to the execution of the deed of settlement. And by the way, I still want to get back to can I split this stuff? That's, to me, still a key issue.
And you're keying on that one part, but look at specifically paragraph 127. All of the allegations of what the misrepresentations are relate to the stock redemption agreement and those conduct.
What's the remedy you're seeking for securities fraud?
For in this case, we're seeking rescissory damages largely. So it's basically not rescission of so we're effectively saying that in violation that we've been damaged and are entitled to have the remaining shares, just the Royals US shares restored, not the EMV interest. This is going to the argument of the Royals.
Yeah, I understand we're going to get to that issue at some point.
Yes. But to us still, Your Honor, because we're looking at the certificate of incorporation and that's a decision that has to get fully briefed. I understand where you went before in the preliminary injunction hearing, but the key issue there is our position is that they weren't tied to each other. You can have a Royals
So
US
it wasn't tied to which?
You were EMV, a sale of an EMV asset allocated to you does not automatically redeem your Royals US share. And that's an argument that's not teed up in this motion right now.
Okay.
But that's effectively what this claim is presuming. We can establish that you can hold Royals US shares without an EMV interest. And this brings back, Your Honor, to the key issue. You can't have it both ways here. If the fact is they're trying to say that somehow, and this was a shifting argument. If you look carefully, a lot of these arguments were not raised in the reply. They shifted their theory. We start first from the premise. Stock redemption agreement presumptively controls. We pleaded that. They have a burden of showing it doesn't. The language is broad, arising in connection with. Every claim, and I can walk you through each one, arises in connection with the interpretation. Because unless they're going to concede, which they have not, that we held the Royals US shares prior to the settlement deed being signed, unless that's conceded,
Say that again?
Unless it's conceded. Remember the argument had been from defendants that we
Yeah,
were
yeah.
redeemed in December
Yeah.
24. Unless they're conceding, we held the Royals US shares as of July 29th, the day before the deed of settlement was signed, then there is no way to avoid the dispute arising in connection with the interpretation or enforcement of the stock redemption agreement. This court itself found the fact of what they won on the preliminary injunction was because we ratified under the stock redemption agreement.
I have no doubt that a significant portion of your claim arises from the stock redemption agreement. And I think I'm persuaded that the stock redemption agreement is going to control over the shareholder agreement, because everything we're talking about arises from that stock redemption agreement transaction. But once we get to the deed of settlement, I've got a later agreement, and that's the one I'm more struggling with. Especially when your allegations seem to say this is fraud because you induced us to enter into the deed of settlement.
We're saying as part of it, that was a condition precedent to the July 25 agreement. We're not trying to
What was the
undo.
condition precedent to that?
They said effectively, right, if you will give you this money plus these rights that you've been long wanting, right?
Who's the we in this?
Defendants, because we're not involved with Sigler, Guff, or anyone in that transaction. This is our dispute here. Our dispute is between three people, right, of the company and these two directors and officers. And they made a bargain and said, right, we'll give you all these promises, right, including the thing you've wanted, the standing, the right to go pursue EMV. But as part of that, this is what you give us. It's part of the consideration. We're not challenging, we're affirming.
What did the defendants get from that oral agreement?
We signed the deed of settlement, and therefore they did not have to, they were at risk, remember, for being zeroed out. They were worried what would happen if we refused to sign. And I think you noted, Your Honor, that settlement deed, I just want to make sure the record's clear, did not actually close the transaction. That was a separate, there were two separate agreements. That was effectively a condition preceding to that closing. Mm-hmm. Not sure whose condition it was, but it was. But why the deed of settlement doesn't control, Your Honor, is just because it was later in time. It doesn't encompass these parties and the nature of the agreement. So you look first, they have to overcome how this one applies, this is the redemption agreement. And because of its breadth, you'd have to be forcing it. Our claims already existed prior to, that contract existed prior to the deed of settlement. And if you want to say, you know, you're pointing to that forum selection clause there, the parties' agreement is not housed in that document. It existed before. It wasn't created by, right? Isn't that word created by arising out of the deed? Because that's after it was executed. What we're talking about is our dispute was created by, arises out of interpretation and enforcement of the redemption agreement. So, Your Honor, if you're going to look at the two, and if they're in any way tied or you're in doubt, Mr. Mayo chose this forum. There is no one saying this forum is inconvenient. Judicial economy, interests, the concession even, that they would have to.
I understand those values. I don't understand what they have to do with the legal analysis.
So if you find, as you said, they all apply. Let's say you have these two that apply. If you have to give one more weight than the other because they equally apply to all the claims, let's say that's, I don't agree.
No, I understand.
But if you do, then the tie comes down to effectively, right, which form is more convenient. And
what's the case that says?
I'm trying to.
Because I thought the Arizona case law said convenience doesn't have anything to do with it unless it's so inconvenient that you lose your right to sue, which you're not challenging reasonableness.
No, well, this would where it would be unreasonable, Your Honor. If you're allowing them effectively, let's say they duped us into that forum clause, that would be fraud, right? Because we were agreeing to an agreement that would be performed and effectuated through Arizona in the United States.
There's no evidence that you were duped into the forum selection. You agree that analysis is not where we induced into the contract, it's where we induced into the clause.
That's why I say that. If you say there's no evidence, we're not challenging the deed of settlement. We're saying we performed it. That was one piece. That's their consideration. That's why it's referenced. We performed. You didn't. You duped us into doing it is fraud. So give us your performance now, specific performance of your promises. That's all we're seeking. So this all falls under that promise, that contract, whether you see it as an amendment of the redemption agreement, whether you see it as a standalone or continuation of it, it all ties back to the stock redemption agreement. So again, going back to the clauses, you don't get to the deed of settlement unless defendants overcome the redemption agreement. The burden is to show it does not apply. The record doesn't show that. We even looking at the deed of settlement, let's go.
I don't understand that argument. I don't understand why they have to overcome it. They just point to a subsequent agreement that covers the same subject matter.
We're under Rule 12b-6, Your Honor. You have to take the allegations on our complaint as true.
I don't think we're under Rule 12b-6. I guess I haven't looked at what the motion has been filed under, but
They did
I mean-
12B3 as well, and we
Yeah.
dispute that 12B3 would apply in this instance, and I can find the exact arguments, Your Honor, but
so in your view, I think we're getting down a rat hole maybe. In your view, the enforceability of a form selection clause at the beginning of the case applies a factual standard that is highly deferential to the plaintiff's allegations. And you can simply allege your way around a form selection clause. I don't think that's true. And then what are you going to do at the end of the lawsuit when we find out those facts aren't true? Which is the way Rule 12b6 works. It says, all right, we're going to move forward. We'll find out if your facts are true. Once we got to the end of the lawsuit, we've already litigated it here.
Your Honor, what my point being there is more of the burden of persuasion and who carries the burden. So if we're in
Okay,
absence,
fair enough.
but my point is if we're in the absence, you're putting the pressure on us to come forward with the evidence that gets out of their argument. The argument goes the other way. They have to show.
Yeah, I'm actually not trying to impose on you evidence. I'm trying to square the allegations in your complaint with two contracts. I'm really not worried about the shareholder agreement. Two contracts that seem to cover the same subject matter, and one that I'm struggling with that deed of settlement.
And let's
So,
look at that deed of settlement clause and exactly what section is it again? I want to go to the language because that you have to.
yeah, I'll give you the number.
Because our agreement, here's, Your Honor, effectively, let's step back on this. The July 25 agreement underlies a lot of our claims. They all tie back to the redemption agreement. The complaint shows, and it's not disputed, the July 25 agreement, according to us, was binding before that was signed. And I know I call that condition precedent, but it was in place, it was affected, it was agreed to. So how could it be modified by the deed of settlement, which is bringing all these different parties and has different clauses, exempts these claims, negotiated? Why? Because we had this agreement here. That agreement.
You're asking me why a written form selection clause would control over an oral agreement without a form selection clause?
Respectfully, Your Honor, it's partially written. I know we say it's oral as well. There's text messages supporting it, but outside of that, Your
Okay.
Honor, the
Not-
agreement, I'm saying the
fair
agreement was reached. So they'd have to be shown to be a meeting of the minds, an agreement by them to modify their terms of their agreement to now change the terms to now go to the UK. There's no evidence of that in the record or no allegation of that. We had our agreement in place and it was binding. If the day before, weeks before, whatever date it ends up being, that agreement was signed.
Okay.
And so that agreement also, again, you can't, if let's go back to the clause. So what section is that clause again in the deed of settlement? Let's see.
It's in 15.2.
15.2. That is exhibit, I apologize, it's G, yes, 15.2. The font all looks the same in these agreements, Your Honor, so, okay, 15.2. So a lot of the cases, and I don't have the site right in front of me right now, when they're interpreting the forum clause, also look at the preamble of the contract to see the purpose and intent of the contract. So if you look here at the beginning, so we're in 15.2, so we'll read this and then we'll go back to the beginning. So in here, Your Honor, it says that the courts of England shall have exclusive jurisdiction. So this one does say exclusive, but in relation to any and all disputes that may arise, so have not arisen yet, may arise, right? Not yet arisen, may, out of or in connection with the creation of this deed, the existence of this deed, validity, effect, interpretation, right? And it's made clear at the end, it's very long, but it's made very clear it's tailored and limited to this. And then elsewhere, I don't have the site in front of me right now, there is a provision in here, Your Honor, in the deed of settlement that we reference in our response that very clearly talks about the ability to bring claims in other jurisdictions or other claims in other forums. And hopefully Dallas or I can find it and give you the citation, and I don't have it right now, but we note it in our response, but it very clearly talks about the right to bring other claims. So if you interpret the deed of settlement in its entirety, which you should, respectfully, you should under that deed of settlement clause, you would have to look at that provision that's effectively saying this is not impacting other claims that may be brought elsewhere. And that's why when you go back to the recitals and the sort of preamble of the case, you very clearly see the purpose of this agreement, which is that it's relating only to waive certain claims against EMV and SG. And so those are the claims that are the subject and purpose of this. And those claims that we're seeking here under the July 25 agreement aren't among those released and waived. Your Honor, is there any other questions? I do want to say, though, respectfully, we did not get a chance to address their shifting arguments. If you go back to their motion, they originally argued certain of the claims, like the July 25 agreement, were under England, and then they later tried to argue Delaware. So to the extent that they shifted your position, we'd ask you not to consider that, Your Honor.
All right. Thank you. Last word, Mr. Campbell, and then we'll do a scheduling conference.
And if I have that site, I'll give it to you, Your Honor.
Thank you.
Just want to make 2 points, Your Honor. First of all, on page 16 of our motion, we list all the forum selection clauses. There cannot be a broader forum selection clause than the one on the deed of settlement. I mean, she only read you half of it. It deals with breach, termination, performance, non-performance. Any legal relationships just satisfied.
It's broad except for the limitation of arising out of this deed or in connection with this deed.
But it says, are any non-contractual obligation arising out of or in connection with this deed? I mean, so it includes both contractual and non-contractual obligations. Further, if you look at 14.2 of the deed of settlement, they say in the deed of settlement, they're not relying on anything that was said to them. That's the integration clause. And they're not relying on anything oral. Now they are. So everything, as you say, it's a later in time, anything in relationship arising out of contractual, non-contractual integration, whether it was breach, that all belongs in England. Judge, the other point I want to make, and I know the court has said, do you think that the stock redemption carves out from the shareholders agreement? This issue of preemption, that the stock was diluted, assume that they're saying we breached a fiduciary duty because they asked us to file a lawsuit and we didn't file the lawsuit. That claim exists without regard to the stockholder redemption agreement, and that clearly is a claim between shareholders. It has nothing to do with the stockholder redemption agreement and belongs in Delaware.
Right.
That's all I have to say, Your Honor.
Thank you. I'll get you a written decision on motion. Let's talk about scheduling order. And I'll just go through the scheduling order. Well, before I go through the specific dates in the scheduling order, I guess I'd like to understand the theme of the disagreement. I mean, is it just that you didn't feel like agreeing to dates, or is it that somebody wants something longer and somebody wants something shorter? You want to talk to me about what you think it is? We'll let you go first, Ms. Sixkiller.
Your Honor, a big part of it, I think, is the speed with which we'd like this case to move forward. I think the largest disagreement, I'll be honest, is we would prefer an early mediation. It's interesting they bring up the mediation in the brief because we have been asking, I'll be frank, we've been asking for one. It's obvious in our papers here. We'd like one for business reasons at the front end. On that
Yeah,
note,
well, let's stop there. I don't have any ability to compel you to do mediation.
understood. And that's part.
And so, I mean, you'll do mediation when you want to do mediation. If you want me to send you to a 3-hour pro tem settlement conference, I'm not going to do it until you're ready to go to it after all discovery. So I think my hands are tied on that.
Understood. So there's an impact on that, but outside of that too, some of the timing relates to the fact that we need to move quickly because of the risk of liquidation with EMV and timing relating to that.
I'm sorry, I don't understand that.
Remember, EMV is going, the team of sale is closing. It's going to go into liquidation, which effectively will cease to exist. Documents will become controlled by the liquidator, ability to even get them right.
And there's no way this case goes to trial in less than a year. That's why we had a preliminary injunction hearing. So do you have some sense that all those things will get done after a year from now, but less than 15 months from now? Because your disagreements are just months apart. So I'm trying to figure out why the scheduling of the trial ultimately is going to be affected by this stuff that's happening in the next few months.
Agreed, Your Honor. My point of raising those two things was to get to the larger reason.
Okay.
So the point was we were pushing for this, which we wanted before certain deadlines occurred to keep costs down. We were hoping by the time we got here, maybe there'd be some reconsideration on that thinking. Outside of that,
I think it's too late to keep costs down in this case.
Outside of that, Your Honor, we were trying to keep things moving quickly, and hence why we were pushing. And frankly, they reversed. Claim 10 in the motion conceded was staying here, right? The promissory estoppel, the reply changes that. We think that's improper, but a lot of the claims that are agreed is staying here. We were pushing to have, if the court, at the time we filed, we didn't have the hearing set on the motion to dismiss. So our key was we wanted to push for deadlines such as answering early. We would like to ask, we're fine on reaching an agreement on the dates, Your Honor. Our key point though is we'd like to request that 26.1s move quicker than under the normal rule. So I guess that's a long-winded way of saying we're here to work with them on the dates in the court, understanding it's a complex case. But as you mentioned, there's been a preliminary injunction here. There's been a lot of work already. What we'd like to do, the parties have documents. It seems to be a delay with a renewed motion here on issues this court squarely found because of that exclusive arises in connection with the dispute arising in connection with language applied. So what we'd like to do is at least, Your Honor, maybe request if we move to their dates that the court shorten, which it has authority to do under at least Rule 1, under the other discovery rules as well, the time for the parties to make their initial disclosures and make their the ESI, so it's not 40 days after that, right? We would like to get moving quickly. That's our main purpose on the dates.
All right, fair enough. Given the choice, would you rather me just pick dates based on what you've submitted, or do you want a chance to try to negotiate something?
My only request would be avoid the fall holidays, if anything. Otherwise, we can work on it. I think their proposal, and I may be confusing my case. I've been doing a lot of scheduling orders, but if it leads to trial in December or January, we would rather, dispositive motions, I'd rather work with them on those dates. But that's it. I mean, we agree and understand if we have cooperation on the UK letters rogatory process. I'd like to note that and discuss that with you too, Your Honor, briefly. Would be that could take, as I mentioned, up to, I think, 8-9 months, we'd say 4 months, right? So that could impact the parties. So we, if you're open to it, I think we both noted in there, the parties did in that section, that we understand we can set dates now, but we'd ask that you understand we might come back as we see how that process goes. And that's one of the things I wanted to raise with you with that is the parties are cooperating on the letters rogatory or the request through the UK, is if there's a process with you that we could help streamline or shorten the timing of.
Like what? I'm happy to. If you're in agreement, I don't know what you need from me.
Judge, I think your suggestion that once you rule, we get together and try and do a scheduling order, it would be very appropriate in this case. And our concern in doing the scheduling order, there are two problems. One, we wanted to know what the claims were before we filed a Rule 26.1. The second is our experience in dealing with the Hague Convention is that it's going to take 6 months. You have to go to the State Department, they go to their State Department, it gets issued by an English judge. Even though we have law firms in London to help us with it, it's going to take 4 to 6 months.
What are you looking for other than, I mean, you obviously want the defendant's communications, but they've got access to those. What do you want from third parties that you're going to need to go to England for?
Your Honor, we have an understanding. So I guess the way discovery works in the UK, even if it's produced by, let's say, EMV to a willing party to give it to us, there's limitations and restrictions on their ability to just give it to us because of the way the discovery works.
My question is, what do you need other than what they already have, the defense already has?
Admissions that the preemption rights were denied. That is a key part of our damage theory, right under each one, saying that we had valid claims.
But those would be in communications with.
They're internal. They will not be with them. So this is,
No, thank
got
you.
it. So it's yeah, thank you. So it's we call it the dentist lawsuit. There's a production that we know is sitting there. We know Steve Quinn, who was sued for allegedly sharing information. He, we understand, has emails that expressly between him and Mr. Badali that expressly will say, again, my understanding is that I don't have them. I'm just saying that's why we need to get the subpoena so we can overcome NDAs or the jurisdiction restrictions.
Okay.
We agree there's documents that need to be had, and then also, Judge, depositions. So those are going to have to be ordered by an English court, I suspect. But the reason I think negotiation would be useful, I think they're operating under a misperception. It's my understanding there is not going to be a liquidation of the company. They've been assuming that there's going to be a liquidation of the company.
Company, you mean Royals US?
EMH. As I understand it, and they don't know this, I suspect that EMH is setting up another company and the proceeds are going to go through EMH to this other company that's going to distribute the monies because it has tax advantages under the English tax system. But if they're concerned about, if they're in such a rush because they're worried some liquidation is going to happen, it's my understanding there isn't going to be a liquidation. There'll be a holdback for pending lawsuits involving EMH. So, but I think once the court rules, if you would just give us 2 weeks to see if we can come up with a scheduling order, that might work.
That work for you?
Yes, Your Honor, we're willing to work with that. We still ask Your Honor to shorten the time for ESI productions under and the timing of Rule 26.1.
So look, if you give me something in 2 weeks after I've ruled, and you still have disagreements in them, now at least we've had the discussion. I don't have to have it again. Just put your differences in there and I'll make a decision on the differences. Do you need anything from me to get the Hague Convention process started? You don't need a scheduling order in place to do that if y'all are working on it.
Judge, it's been a few years since I've done one. It seemed to me we had to get a stipulated court order.
Right, get it to me, I'll sign it. Yeah,
Your Honor, briefly, I don't have all the sites yet, but at least section 5.4 of that Exhibit G, the deed of settlement, talks about nothing in this agreement shall prevent the releasing parties or any one of them from taking any action. So
yeah, that's part of the release, the release claim section.
that's in the covenant not to sue,
Got it.
section 5.
Judge, we have not released anything. And we have no intention of releasing anything. I don't know what.
No, that's going back to the argument as to the scope, Your Honor.
Yeah, I understood where we were going with
The
that.
purpose and intent, knowing they'd be bringing claims somewhere else, Your Honor. So
Okay.
on that note, Your Honor, I don't think we need anything. The key is there's letters rogatory. We have to have you issue. We have cooperation. The parties will work with you on that and lodge it. And if there's an issue on timing, then we can.
Yeah, I mean, those things, stipulated things don't sit.
Correct.
So just
Yeah.
give me a stipulation and you know, tell my staff, they'll say on the front that it's expedited and we'll get it signed. Okay. All right. I think that covers it. Anything else today?
Not from defendants.
No, Your Honor.
Nice to see y'all. We'll be in recess.